Good afternoon. My name is Lisa Gonzalez-Goetz. I am an attorney who exclusively practices Social Security disability law, and I'm here today to see if I can help answer any questions that you have with regard to obtaining Social Security disability benefits, Medicare, Medicaid, SSI, anybody who is sick and needs some clarification of their benefits, or anybody who may have questions as to whether or not they qualify. So please ask away and I will be happy to answer any questions. Okay, so my first question is, what is the difference between SSI and SSDI? So there's several different programs which would give you the benefit of receiving Social Security disability. But basically there's two main titles. One is Title II, which is disability insurance benefits. And Title II are for people who have worked and paid money into the system and are receiving the monies that they're entitled to at the age of 65. They're receiving it earlier based on their impairment. They can get it early. That's Title II. Title 16 is where SSI comes in. That's supplemental security income. So those are in the cases of children that have not paid into the system, or somebody who may have worked but not enough quarters of coverage. So they would be treated as an indigent person and actually file the application for SSI. And with the SSI comes the Medicaid, and with the disability insurance benefits, which is the Title II, comes Medicare. So two different types of insurance that you would be entitled to, depending on what application you file and depending on when your benefits are granted. Okay. So I have another question here. Somebody wants to know, how do I apply for Social Security disability benefits? So the application process is a lengthy process and it's a lot of paperwork. You could do it online, or you could do it through an interview with Social Security. So in our office, which is Gonzalez-Goetz, we do it at any stage. We apply for a person who is not working for 12 months or more, or for a person who's expected to be unable to work for 12 months or more. And we'll file the application electronically. If you want more information on that, you can call myself. My number is 954-764-8989. You can email me at lisa@gglaw.info, or you can call Social Security directly. And that number is 1-800-772-1213. What you have to remember about filing for Social Security disability is that you are filing because you have a condition, a medical condition, whether it's physical or mental or combination, that prevents you from working full-time for a period of 12 months or more. If you feel that you qualify under that, then you also have to make sure that you are receiving medical treatment and care for the condition. So you can't file disability saying that you are not able to work because you're sick, but you don't have a doctor treating you. That's not going to really be successful. So I encourage anybody who has a doctor to ask them straight up, would you be supportive of me if I find that I'm not able to maintain a job? And with that, then the application gets started. Again, if you want to email specific, I'll be happy to read the emails and answer. That's lisa@gglaw.info. And the firm is Gonzalez-Goetz. Social Security is a federal practice, so it goes across any state. for any individuals who would qualify for benefits. So there's not a particular attorney that only works Social Security in one area. So we go, for example, my husband and I go nationwide. We take cases all across the nation. Then you also have people, for example, that have lived here and then move out of state or out of the country, and they can continue receiving benefits. So I'll be happy to answer any questions regarding that. I see an email question. What are the benefits of hiring an attorney to help you with your Social Security case? So the government has really no incentive to pay and give benefits to individuals, mostly because the checks and balances are not there. And once you're given benefits, even though you do get reviewed, it's lifetime. There's many stages to the application. So you first file an application, then you get denied. You have 60 days to file a reconsideration. Then you have 60 days from a reconsideration denial to request a hearing. At any stage of the game, you can hire a lawyer. You can do it at the beginning, or you could do it when you have a hearing scheduled and you get nervous or intimidated and you don't want to go in. What you should know about this particular area is that any attorney charges the same amount of money at any time, and we are statutorily, we cannot go above $6,000, and it's only based on 25% of what we get for you, up to $6,000. So that's whether you hire an attorney to do your initial application or to do your appeals or to go into court with you. It's a standard fee agreement. So when I look at it, I think if there's an attorney that practices exclusively Social Security disability, there's a need for that. So I would really advise everybody to get an attorney because they don't charge unless they win. And also, if you have an attorney working on your case, those appeals of 60 days, you can't let them expire. So somebody has to be responsible. And when we're sick and we're often medicated or we have difficulties with day-to-day activities, those things get overlooked. And if you're paying the same amount either way, in the beginning or at the end, then you might as well have somebody in the beginning. I would conclude with the question about attorneys, which be very careful who you hire, and ask, don't be afraid to ask, what percentage of your practice does Social Security disability? What percentage? Because some attorneys dabble and they really don't know this area as well as some others. So some workers' comp attorneys do this and other things. But if somebody like our practice only exclusively Social Security, I think that you would get the best advice and the best results because of that. How long does an appeal take to get a hearing? Okay, that depends on the jurisdiction, what state you're in, what county you're in. If you have a question, you can, of course, ask me directly based on where you live. But I will tell you that down here in Florida, Dade County is taking longer than Broward County. An appeal can take from the request for hearing, from when you appeal and you're asking to go in front of a judge, to the date of a hearing, can be as long as 18 to 24 months. Okay, and when you apply for benefits, you've got to know that you're going to be out of work for 12 months, and you have to anticipate that your case will take anywhere between 3 or 4 months, which is very rare, to 3 or 4 years, which is, I would say, at least 2 to 3 years is what the life of a case. And then again, it depends where you are and how many judges are there and how quickly offices work. So sometimes Congress is trying to put in judges from other states to hear cases in municipalities that are very low production, like Miami. And sometimes in Fort Lauderdale, they'll bring visiting judges, and that will help scale back the delay time of cases that have to be heard. Let's see. I'm trying to see if there's any other questions. Yeah, I got another question. What health records do you recommend when applying for disability benefits? So like I said before, it's really important that you have your doctor on board, because we are going to ask for questionnaires and forms to help explain why are you not able to work a 40-hour work week. So for example, if you are in need of a lot of unscheduled breaks, as an example, and you're not able to be at your workstation a consistent amount, that's important to know. You have a financial gain by saying that. So what you say is not as important as what your doctors say or what your complaints and your medical records are. So what health records are important? All of them. If you have lupus, if you have Crohn's, you are not applying only for those levels and that impairment. You are applying because, excuse me, you are unable to do any kind of work. And it's not only because of the physical component, it's also the side effects of the medication. It's also drowsiness, fatigue, which is not real quantifiable other than in your medical records. Then there's the other component of anxiety, of fear, of non-exertional impairment. And what that means is all the other reasons why I don't want to get out of bed. So all medical records are important. Some people don't want to supply us with psychiatric notes because they want to keep it only as a physical case. But I would suggest, and I do this to all my clients, that any and all impairments, any and all medical records there come into play, because we don't look at you only as lupus. We're looking at you as a spectrum. We're looking at you based on your past relevant work. We're looking at you based on your impairments for which you get treated for, the side effects of your medication, your age, your education. It all comes into play. So it's really very important. An appeal in Orange County, from the same person who asked how long does an appeal take to get a hearing. Orlando, is Orlando Orange County? I think it is. Mm-hmm. And if it's Orlando, I will tell you that Orlando has a much quicker rate than Miami or Broward. It may still be 112, 130, 160 days from the request for hearing to a hearing with a judge, which means that from the application date and appeals pending, it could still be 2.5 years. Orlando Office of Disability and Adjudication and Review has just said that they're going to also be helping the people in Puerto Rico. Not sure quite how that's going to work, if they're going to shuffle judges from Orlando down or shuffle clients into Orlando. So right now, if your case is pending in Orlando, you're in line, but be aware that even though Orlando is a high producing office, if they are going to take on a backlog that's sitting with all the natural disasters, it may impede or affect your case a little bit. Okay. I have somebody who says that they have applied 4 times and was denied, and they don't really know what to do about it. So sometimes we get confused with the terminology. So an application for Social Security disability is when you first do that one application and you file and you say, I can't work, I am disabled. If they deny you, then you're requesting a reconsideration. And that's an appeal. That's not an application. That's an appeal if it's done within 60 days. If those 60 days pass, now you can't appeal anymore. You have to start and reapply. So I'm not sure when you say you have appealed or applied 4 times, what it means. But normally, just for everybody to understand the process, you first apply as an initial application. If they deny you, you have 60 days to appeal, and then you ask for a reconsideration. If they deny you, you have 60 days to appeal, and then you ask for a request for hearing in front of an administrative law judge. If at that time the judge denies you, then you can go to the Appeals Council in Virginia, and it's a written brief. And that's done in the offices. It takes more time, but it talks about what went on in the hearing and the mistakes that the judge made. If that gets denied, then you can go into federal district court. You have to be licensed to go into federal district court in the area that you live in, and you say there was a mistake in law. So if at that stage you get denied, then you're looking at really appealing to the Florida Supreme Court to make law. So we have one case like that in 25 years that we're starting to work on. So if you've applied 4 times, I'd really say try to understand that whether it was an application or an appeal and where your case is at. And with permission, we're able to look and tell you exactly where your file is and whether you need to apply or appeal. Those are different things. So again, you can email me, and that's lisa@gglaw.info, and we can deal with that on a case-by-case basis. Okay. A question about whether every person who does an application has to complete what is called a physical ability assessment prior to being reviewed. Those are physical forms. There's also some mental forms like that. They're government approved forms, and they try to break down your activities of daily living, and it's trying to really explain what it is that you can and can't do. How long can you sit? How long can you stand? How much can you stoop, bend, lift, carry? Those forms can be very, very helpful in your case because they erode the occupational base. They show that there's no work that you can do. Likewise, if you're able to sit for 6 out of 8 hours a day, if you're able to lift a certain amount of weight, and if your concentration is good enough that you can answer phones, then that's a job, then you would not be disabled. Those forms are done by Social Security automatically at lower levels, and then we also ask for the help of your treating doctor so that with those forms we can actually help show that you can't do any work. Somebody is asking me that they got denied, and they were denied because of the education that they have and the past relevant work experience. So this person happens to be in Orlando again, but this is a nationwide practice. So Social Security has to determine if a person with your past relevant work history, your education, and your age is able to do work in your field. So I'll give you a very classic example. I had a doctor who had Parkinson's, and Social Security said, okay, so you shake a little, but you're a doctor. And as a doctor, you could teach, you could write, that's a job, and therefore you're not entitled to benefits. So we were able to prove that based on his age, his education, and his work experience, he qualified for disability based on the work he did. So Social Security uses that perfunctory very readily to deny people, okay? Because the burden of proof is that there's no work that you can do in the national economy. So in your case, perhaps if you're over 50 and you've worked in a work that's a skilled work, you're going to have a little harder time proving disability than somebody who's your same age with no real education and was picking tomatoes, for example. So the kind of quality of work that you did does impact, because it talks about transferability of skills. It doesn't mean that you don't qualify. It means it's easy to deny you based on that. Somebody's asking about citizenship. Are only American citizens able to apply for Social Security disability? And the answer is no, not if you've worked and you qualify for Title II benefits. So if you have paid Social Security taxes and you've worked, as a rule of thumb, 5 out of the last 10 years, 5 out of the last 10 full-time work, if you have done that, then you are entitled to get benefits, whether or not you are a citizen. You could be a resident. However, the law changed with regard to SSI, and SSI is not available for residents that have been here for less than 10 years, because SSI is a welfare type program. So those are different programs, different interpretations of the law for different people. So that's on a case by case. And again, you're welcome to email me and about your particular case, and I will answer the emails and discuss exactly what you're eligible for. And just in case you need it again, it's lisa@gglaw.info. Okay, so I'm okay. We're doing this for 15, 20 minutes. It's been 25 minutes. I want to know if there's any other questions that you may have out there, because I would be remiss if I'm not answering these questions. And I have devoted this time for you. So I'll go as long as they will allow me to go, and as long as you have questions. So I got a question that somebody's 30 years old, working in the medical field, but has heart issues and fibromyalgia and doing chemo. So again, you have to be out of work to qualify for benefits. So you have to know that you're not going to be working on a consistent basis. And that's a question that only you and your doctor can answer, as to whether or not you feel you can maintain your job. If you're not able to work because you're impaired, you're not able to consistently show up to work, and you're dragging, and your doctor will support you, then I would say yes. If you're in chemo and it's expected to last 12 months or more, you file for benefits right away. And the age is just an issue with regard to denying you. They may deny you quicker because you're younger, but it doesn't mean you're not entitled to. Okay. So I think we're good. I'm going to give you guys a couple more seconds to see if there's anybody who has any other questions that they want to, jot down.
Yeah, like a recap almost.
Yeah, of course. So in recapping, should you contact SS if you're awaiting a hearing date and haven't heard? Of course, you should contact Social Security. If you're waiting for a hearing, I would strongly advise you to get an attorney. Never go into a hearing without an attorney. I've been doing this 25 years. I've been here through a lot of different administrations. And I would say that a case is totally different when you have an attorney backing you up and collecting your medical records and fighting for you at a hearing. Hearings normally have a medical doctor that's a government hired person, as well as a vocational expert that talks about the job. So there's a lot more that goes into a hearing, more than just your impairment. So you can contact Social Security. If you have an attorney, have them contact Social Security. But as you know, it's a bureaucracy. Congressmen, congresswomen, they help in trying to speed it up a little bit. And I would be happy to answer any questions. I do these programs all the time for multiple different agencies, all on a nonprofit basis, because I believe it's really, you need as many advocates as you can to help you overcome the bureaucracy and the paperwork and the difficulties that they put on clients. So again, my name is Lisa Gonzalez-Goetz, and the Goetz is spelled G-O-E-T-Z. The O is silent. Our website is www.wegetyourdisability.com. And it's wegetyourdisability.com. And again, my name is Lisa Gonzalez-Goetz for anybody who may have any questions and is frustrated with the process and hasn't heard anything and may want a little bit of assistance, absolutely feel free to call or email. No strings attached, just to know whether you're going in the right pace. And we take cases in Florida and nationwide. We take cases all the way to American Samoa, Guam, Hawaii, very active there. We have cases in Puerto Rico, and we also have some cases internationally because people that work in the government paying taxes here can move anywhere and are entitled to benefits. So we recently won a case for a client in Israel, and we have a couple more cases in Europe. So everything is done electronically. It doesn't have to only be in Florida, but we are headquartered here in Boca Raton. Okay, thank you.